Hello, good afternoon, guys. Welcome to MP Convenience Brokerage. My name is Mohammed. In this video, I'm going to go over Notary Public License Law. Basically, I'm going to be going over some of the terminology of Notary Public. I'm going to explain to you, basically, this is what they're going to be testing you in the test. Hopefully, I'll be giving you a brief more explanation so I can help you guys pass the Notary Public in New York State. So, you could check out my channel. I did describe how to become Notary Public, what's the process of doing so, and your way to go take the center test in New York City. If you go check out my channel, you can actually find out from there. This video is basically, I'm just going to go over some of the rules and regulations of Notary Public, what are the requirements, how to apply, stuff like that. So let's get started. Now, this is the introduction. Obviously, Notary Publics are commissioned by the Secretary of State. Keep this in mind. You're commissioned by the Secretary of State. This is one of the test questions they usually end up asking you, who a Notary Public commissioned by. So keep this in mind. The Secretary of State. An applicant for Notary Public commission must submit to the Division of License Service an original application and $60 fee. The application includes an oath of office, which must be sworn and notarized. In addition to the application form and fee, the applicant must submit a pass slip showing that he or she has taken and passed the Notary Public examination. Examinations are regularly scheduled throughout the state. An individual admitted to practice in New York State as an attorney may be appointed as a Notary Public without an examination. The term of commission is 4 years. So basically, if you want to be a Notary Public, you'll basically have to take a test, as described below. Pay the $60 fee, obviously, and once you do that, you'll have your license issued, and your issued licenses will be sent to by your home. So the only people that exempt are basically attorneys. They don't have to be, they don't have to take the Notary Public test, because they obviously what they go through with their studies, and once they pass the test and everything, they're exempt from doing that. Just keep this in mind. This is whatever I'm telling you over here. This is very important, because this is some of the questions they can ask you during the Notary Public test. Keep this also in mind. You're commissioned for 4 years, not 8 years, not 10 years. It's only good for 4 years. Notary Publics are commissioned in their counties of residence. After receiving and approving an applicant for Notary Public commission, the Secretary of State forwards the commission, the original oath of office, and the signature of the Notary Publics are to the appropriate county clerk. The county clerk maintains a record of commission and signature. The public may then access the records and verify the official signature of the Notary Public at the county's clerk office. So whichever signature you have in the Notary Public, obviously once you pass the test, because you also need to send documents with the pass slip as well. Just make sure your signature, whatever you send them, that's the signature you're going to be using to notarize other people's documents. Keep that in mind. Upon request, county clerks will authenticate the signature of the notary on a document and will attest to the notary authority to sign. This is normally obtained when the documents will be issued outside the state. Notaries who expect to sign documents regularly in counties other than their own residence may elect to file a certificate of official character with other New York State county clerks. Out-of-state residents, attorneys residing out-of-state who are admitted to practice in the state and who maintains a law office within the state are deemed to be residents of the county where the office is maintained. Non-residents other than attorneys who have offices or a place of business in New York State may also become notary. The oath of office and signature of a notary must be filled in the office of county clerk of the county in which the office place business is located. So this is some of the Notary Public, terms. You can see appointment qualification. I'm not going to go over one-shot deal telling you everything. I'm just going to go over a little, so obviously it doesn't become too much of a burden to digest these documents. We're going to go over the first 2 pages, first 2 to maybe 3 pages, because there's a lot of information to digest again. Hopefully I can explain to you as much as I can. So let's get started. So professional conduct. Use of the office of notary and other than the specific step-by-step procedure required is viewed as a serious offense by the Secretary of State. The practice of taking acknowledgement and affidavits over the telephone or otherwise without the actual personal appearance of the individual making the acknowledgement or affidavit before the authenticated notary is illegal. What does it mean? It's simple. If you're a Notary Public in New York City, let's use New York City as an easy example. The 5 boroughs. If somebody comes up to you and wants to notarize a document, but the person, let's say for example, calls you up actually and says, you know what, my name is John Doe, I want to notarize a document. Would you be able to notarize a document? No. In New York City, you have to have somebody in front of you. basically New York State, should I say. The person has to be formally in front of you, and that's the only time you can notarize a document. You cannot notarize a document anyone else if you don't have them in front of you. The court again wishes to express its condemnation to the act of notary taking acknowledgement or affidavits without the presence of the party whose acknowledgement is taken for the fine, and that is will treat serious professional misconduct in the act of any notary thus violating his official duty. And upon the faith of these acknowledgments rests the title of real property, and the only security in such title is the fidelity with which notaries and commissions of deed perform their duty in requiring the appearance of party to such instrument before them, and always refusing to execute a certificate unless the parties are actually known to them, or the identity of the parties executing the instrument is actually proved. Now, what does that mean? It's simple. Let's say, for example, as a notary public, let me go over this first. When you notarize a document, the first thing you need to ask for proof. Let's say a third person, you don't know anyone, you never seen that person in your life. You need proof. A driving license, passport card. Make sure that it's authenticated, it's real, it's not fake. Once you figure that out, then you look at the document. What document is you notarizing? Asking for it. Certain documents as a notary public you can't do it. For example, it's strongly frowned upon. You cannot notarize a will. Usually attorneys and practicing lawyers do that. But let's say, for example, somebody comes to you. You check the document. You see everything's good. You notarize the document. With checking the credential, you take that information and you put it in your notary logbook. If you have a logbook, basically you get that. You can get it from anywhere in this notary store, or you can get it online. The logbook will state the person's name, the address, the date of birth, the driving license information, telephone number if that person is willing to give, email address just in case. All the information, the date and time the person was notarized, have all the information in the notary logbook. So that's what the proof should be on your part. And let the person sign in your logbook, and you sign as well, authenticating that this person was here. So this should be basically a good example of that. So but if you don't know somebody, let's say for example, if you know somebody, let's say for example your friend or somebody that's like a third party relationship, not brothers and sisters, you can't notarize their documents, father, uncles, you can't, not even grandfathers, grandparents, you can notarize it, but strongly frowned upon not to. But let's say if your best friend wants to notarize a document, you don't need that person's information. You don't need to get the license. I would actually get that information just for record purposes. But let's say, for example, that you know that person, you know where he lives and everything, then you can actually basically notarize that document without any identification, because you know that person for quite a while. You could attest for that. So basically, that's what this small paragraph is saying. Equally unacceptable Secretary of State is slip hold administration of oath, and simplest form in which an oath may be lawfully administered is, now these are the oaths that you could do to other, if you're a notary public. This is one of them. Do you solemnly swear that the content of the affidavit subscribed to you is correct and true? That's one. Or this is another one. Do you solemnly, sincerely, and truly declare and affirm that the statement made by you are true and correct? These are two of them, obviously. Statement. Keep this in mind, they're a little bit different. This is for alternatively, the following information may be used for a person who consciously declined the taking an oath. If somebody declines taking an oath, this is one. If they don't, this is if they do decline, this is what you have to read them. So whichever form you adopted, this person has to swear in front of a notary officer or an authorized administration, and obviously it must be unequal and present act of which the offender consciously takes upon himself an obligation of an oath. Let's go over here. Unless a lawyer, the notary public may not engage directly or indirectly to the practice of law. Listed below are some of the activities involving the practice of law which are prohibited and which subject the notary public to removal from office by the Secretary of State. As a notary public, you're not supposed to do some of these things. For example, you may not give legal advice on law, because you're not a lawyer, you cannot do that. You may not ask for and get legal business to send a lawyer. For example, if you're a notary public, you can't tell your clients, like, okay, you could go to this place, to this lawyer. You can't refer. You may not advise or agree to divide. You cannot do that with another lawyer or with anyone else. You may not advertise or circulate in any manner or any paper advertisement whatsoever. You cannot do that. If you do, you could get in big trouble. So a notary public is cautioned not to accept acknowledgement of the execution of a will. Such acknowledgement cannot be deemed equivalent to the necessity clause accompanying a will. Keep that in mind. This is the execution laws, certain over here, disqualification and everything. Appointments in notary public. The Secretary of State may appoint any commission as many notary public for the state of New York as in his or her judgment may be deemed best, whose jurisdiction shall be coextensive with the boundaries of the state. The appointment of a notary public shall be for a term of 4 years, like I said before, and the applicant for an appointment as a notary public shall be informed set forth such matter as the Secretary of State shall prescribe. Every person appointed as notary public must at that time his or her appointment be a citizen of the United States, either a resident of the state of New York or have an office or a place of business in New York State. A notary public who is a resident of the state and who moves out of the state still maintains a place of business or an office in New York State does not vacate his or her office as a notary public. A notary public who is non-resident and who ceases to have an office or place of business in this state vacates his or her office as a notary public. A notary public who is resident of New York State and moves out of this state and who does not retain an office or place of business in the state shall vacate his or her office as a notary public. A non-resident who accepts the office of notary public in the state thereby appoints the Secretary of State as a person upon process can be served as his or her behalf before issuing to any applicant or commission as a notary public, unless he or she has an attorney and counselor of law duly admitted to practice in the state of county clerk of the United States court system, who has been appointed to such position after taking a civil promotional examination in the court clerk series of titles and Secretary of State. Basically, what they're saying is simple. If you're a notary public, you know your rules, not more than 4 years. That's what you commission. You commission by the Secretary of State. Lawyers are exempted. Basically, that's what the whole paragraph is they're trying to tell you. I'm just going to go over the important key points because it's too much. I mean, not all the information you need to digest. I'm just going to go over important key points. So these are some of the illegal things that that you might get disqualified for being an appointment on a republic if you're convicted of this. Keep this in mind. Not all felonies you can get convicted of a notary public. Let's say for them being a felony, you can still apply. But if it's one of these listed, it gets a little bit hard to get a license in notary public. So, illegal using, carrying, possessing a pistol, or other dangerous weapon. That's one of them. Making or possession burglary instrument. That's second. Buying, receiving criminal possession, stolen property. That's third. Unlawfully entry of a building. That's fourth. Aiding escape from prisoner. Unlawfully possessing or distributing habit from narcotic drugs. Violations, all these. And vagrancy or prostitution. That's another one. Person regularly admitted to practice as an attorney and counselor in the courts of record of the state whose office or practice of law is within the state may be appointed a notary public and retain his or her office. Such notary public, although he resides or removes from adjoining state, for the purpose of this and the following section of the article, such person shall be deemed a resident of the county where they maintain such office. So procedures, appointment, fees, and commission. This is important. Keep this. This is very important. This is a lot of questions do come up from this. So keep this in mind. I'm gonna tell you what they will ask you and basically what it is. Applicants of a notary public commission shall submit to the Secretary of State with the application the oath of office executed before any person. Upon being satisfied with the competency of good character of applicant for appointment as a notary public, Secretary of State shall issue a commission to such person. The Secretary of State shall receive a non-refundable application fee for $60 from applicant from appointment, which fee shall be submitted together with the applicant. A notary public identification card indicating the appointee name, address, and accounting commission term shall be transmitted to the appointee. The commission duly dated and a certified copy of the original oath of office, an official signature, and $20. Keep this in mind. This is important. $20, a portion from the application fee shall be transmitted to the Secretary of State to the county clerk in which the appointment resides by the 10th day. These dates, keep this in mind. These dates are very important. The county clerk shall make a proper index of commission of the official signature transferred to the office of the Secretary of State pursuant to the provision of the section. Let me see which one are more important that they might ask you. Let's see. Over here, the county clerk shall receive a non-refundable application for a fee of $60 from each applicant for reappointment. So, which fee shall be submitted together with the applicant? So keep these in mind. These numbers are very important. These are the questions they might ask you. How much did it take? How much is it all together? Who are you? Notary Public Commission by what state? All this as well. This is actually one of the questions they did ask you. Except for changes made in an application for a reappointment, the Secretary of State shall receive a non-refundable of $10 for changing the name and address of a notary public. This is important. This question they asked me last time when I took the test. The Secretary of State may issue a duplicate identification card to Notary Public for one lost, distorted, damage upon application thereof of form prescription by the Secretary of State upon payment of non-refundable fee of $10. This as well. This was a question as well that I remember. Each such duplicate identification card shall have the word duplicate on it, stamped across the face thereof, and shall bear the same number as the one it appears before. Certificate of official character of notaries at the Secretary of State or the county clerk in which the commission of notary public is filed may certify to the official character of such notary, and the notary public may file the autograph signature and a certificate of official character in the office of any county clerk of any county in the state of any registered office in any county having a register, and thereof such notary public may clarify as to the official character of such notary public. Basically, if you want an official character of like Notary Public, your signature or anything else, you can go to the county clerk office and get it from there. I'm not gonna go over anything else. It's a lot of information. I know it's kind of dry, but this is how the test is. I would recommend reading this a couple of times before you take the test, because a lot of questions that you might not seem repetitive or might seem repetitive, that's what they are. Like for example, Notary Public commissioned by Secretary of State. What's the amount that if you want to apply for everything? $60. Non-refundable fee is $10. Duplicate, you could have apply for duplicate license, but duplicate is going to be on it. These are some of the questions that they ask you during the Notary Public test. So keep this in mind. Don't take it lightly, because a lot of people do take it lightly. Don't pass the first time. Just study, and there's also study materials out there that can also help you when you take the Notary Public test. Other than that, that's about it, guys. Thank you again for watching this video, and I hope you guys enjoyed it. If you guys have any other questions, comment, concern, please comment, like, subscribe. I'll try my best to comment to you guys or help you out as much as possible. Thank you again, guys, for watching this video, and I hope you guys enjoyed it.